Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
August 2nd.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's to advise you of why you're here.
Oh, okay.
What your bond is, and give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the. We'll file it in the file.
Yeah. But I'm not going to sign anything though. I'm not going to sign anything.
Well,
yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other.
I don't.
When is the last time that you worked?
About a year ago, maybe a little over a year ago.
Buckle up, guys. Today we're going to witness a stunning clash of street smarts and legal procedure. The camera catches Mr. Walker's nonchalance as he dismisses the need for counsel, challenging the court's authority. Despite facing a $10,000 bond and probation violation, his swagger shines. The judge's offer of standby counsel lands awkwardly in the silence. This opening gambit sets the stage for a courtroom drama where confidence meets consequences.
All right, how old are you?
How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm
a little over a year ago.
Okay, so I'm going to go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll be around and be available for you. Okay.
Yes, ma'am. I'll take counsel, no doubt.
All right. Thank you, sir.
Okay, thank you.
All right, let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. This is the city of Detroit versus Albert Hicks Jr. Appearance for the record, please.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
Your own attorney. You're an attorney registered by the state of Michigan.
You don't have license to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything.
Okay, you have been practicing law across the bench since we started this, and I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date, or you want the office in the back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right, well,
I'm
trial
challenging
date,
jurisdiction.
trial date, I'm denying, what is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so,
Honor your oath of office, please. Honor your oath of office, okay?
are we going to sit here and debate those
If it's not a
positions?
debate, it's my constitutional right.
Mr. Walker's defiant waiver unfolds as he boldly refuses to sign any paperwork, forcing the judge to appoint standby counsel. His noncompliance echoes through the courtroom, revealing a man unmoved by protocol. The judge's patience frays as he navigates procedural chaos. This segment sharpens tensions, exposing the thin line between self-representation bravado and the reality of legal safeguards. It's a stark reminder that courtroom rules trump bravado.
It's my constitutional right.
You think so?
I
Okay,
know
so,
so. Are you violating my constitutional rights on how you deem them to be?
no, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a
Please.
transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you gonna do today, Mr. Hicks?
Challenge jurisdiction
And how are you challenging that?
because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am, in this case,
Okay.
and I deny that motion.
Why you
If
deny
that-
the motion? Because you don't have.
Even if that is, so Mr. Hicks, you're a grown man.
Citation needed.
Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now
Okay.
let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one. Wait a minute. You were the one, Mr. Hicks, that said, "Oh, you can say all that while you're on the bench." That's what the court rules are. You got to follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything. That's all public
Oh,
information.
you're acting tough now? You're acting tough now? Behind the bench?
You watch Albert Hicks theatrically insisting he's his own attorney, challenging the judge's authority with constitutional rhetoric. The bench counters by demanding bar credentials and slams motions outright. His courtroom theater collapses under procedural reality as the judge reclaims control. This exchange lays bare the clash between sovereign delusions and strict legal protocol. It proves that procedure trumps performance every time.
Mr. Hicks, let's not go there, all right? Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes,
yeah,
I did.
I thought about that.
I don't even have a
I
license
thought
to
about that.
practice law.
Listen, this
You
whole
don't have a license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to
talk?
You really want to do this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course I do.
All right, I'm moving on.
All right, moving on.
You didn't answer my question, so I'm moving on. And I'm going to put you out, or at least mute yourself. All right, let's do this, and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, D.A. Chiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
A courtroom twist unfolds as Judge Perkins faces no-show officers for Hicks's DV case. With no prosecution present, the judge dismisses charges and even muses about awarding defense fees. Hicks's smug grin meets the weight of dropped counts. This segment flips expectations, reminding viewers that procedural absence can be as powerful a weapon as any argument in court. It's a vivid reminder that sometimes silence speaks louder than evidence.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we going to do? The officers were supposed to be here today. I'm only dealing with SP15, SP144, 2547, counts 1, 2, and 3, SP144, 27651, and SP5008721. I'm only dealing with those matters. And the officers are not here. So we're going to make this easy. And now, what I don't appreciate is, I thought about that comment that you made that last time. Basically, you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this. I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man. All right, I'm going to dismiss the cases because no officer appeared.
I would like to pay my cost and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, bye.
Close attention to the look on his face as she testifies against him at his probable cause hearing.
Is that Mr. Elmer Hicks? Yes. Okay, and how do you know that person? He was my partner, and he is the father of my children. Okay. How long were you guys partners for? 14 years.
In Washington, we meet Schuster, an American-born seeker of sovereign status, deadpanning his claim to non-U.S. citizenship. He weaponizes archaic legal language, demanding proof of jurisdiction before he even pleads. The judge remains unflappable, reciting charges, suspended license, expired tags, ignition interlock refusal. Their standoff dramatizes the collision between archaic theories and modern enforcement. It shows how reality trumps fanciful sovereignty.
So, for the record, I've made this special visitation under duress pertaining to the matters of Jonathan Troy, Faifu Leaso Maliatoa Schuster. For I am beneficiary, I am sovereign, I am man, the flesh lives, the blood flows. I am a non-U.S. citizen, American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status. And so I ask you, ma'am, what is your name? What is your nationality? And what is your status?
I'm Judge Grant. I am a citizen and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I've challenged the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting sued.
The judge verifies probable cause on multiple infractions: driving suspended, missing interlock, expired registration, and formally enters a not guilty plea on Schuster's behalf. The courtroom dances between deference and firmness as the bench navigates his sovereignty spiel. That calculated plea entry anchors the legal process. Proven procedure can't be sidestepped by grandstanding. It's a perfect illustration of how procedure prevails over performance.
It would just add to that. And I don't think that you need to go that route.
While I review this incident report. Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury. All right, I do find probable cause with the charges. I will be entering not guilty pleas.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the law.
Unless you want to enter a plea of guilty, today there'll be a plea of not guilty. Understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but
To question my competency because I'm evoking my, or not evoking, I'm sorry, establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice.
in the city of Lake Forest Park, you were violating.
Again,
laws.
I was not driving. Again, I have rights.
You were behind.
And my rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am
you.
Sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.
With prior FTAs and temperament on the table, the judge sets Schuster's bail at $2,000 and imposes strict conditions. No new offenses, valid license, insurance. Schuster doubles down on self-representation, invoking sui juris and reserved rights. This standoff spotlights trust issues between bench and bail discourse, underlining that rights don't negate responsibility. It's a stark reminder that freedom requires accountability.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him. I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also indication that Mr. Schuster will not abide the court's orders to appear on his promise. I want to look at the Seattle Municipal case and see when he's next scheduled to appear.
Like he had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifale, also Maliatoa Schuster. I'm a man, I'm free, and I want it to stay that way.
I do see it looks like he's got at least 3 prior warrants. He has 2 priors out of Benton County, 1 out of Lower Kittitas.
Should have
The
been cleared up.
previous warrants history.
And throughout this process of going to courts, I've
Eric Martin storms in invoking the Roman cessate trust, refusing to identify himself. He couches his presence as a corporate fiction dispute, bewildering the clerk. The judge calmly reiterates his charges, domestic violence, misdemeanor potential, and lays out the plea process. This moment crackles with absurdity, showcasing how sovereign tactics collide with real-world allegations. It's a surreal blend of corporate law fantasy and sobering criminal reality.
And so I know it's no game to just not show and make visitations. That's not what I want to do. And again, jurisdiction does need to be proven, whether it's today or another date. And if you want to violate my rights even further by not releasing me on my own recognizance, ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I don't see another date set until February 12th of 2025 in the Seattle.
In Seattle Municipal Court?
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail. And any threats to sue me or to take any action against me, I can't be swayed by that. So
It's not a threat. It's just what it is. Because my rights have been violated, and if my rights are going to be furthermore violated.
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case, as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance. And
when are you setting that court date, Miss?
Required by the Department of Licensing. You will be represented, because I'm going to assign counsel.
I am sui juris in propria persona. I present myself. I don't need to be represented.
That have significant consequences for you. So it's in your best interest to have counsel.
Again, I stand on my own 2 feet. I do not need to be represented by anybody. I present myself, sui juris in propria persona.
If you want to be your own counsel, you'll have to go through a full colloquy and waive all your rights to have representation. It's your constitutional right.
I do not accept being represented by anybody. Again, I present myself. I am beneficiary. I am sovereign. I am an American national, a non-U.S. citizen American national by way of America Samoa, like I had mentioned earlier. I reserve my rights, and I do not need to be represented by anybody.
All right. The time for trial expiration is 8/9/24.
Again, if you are practicing law from the bench and putting a plea in for me, I object to that. You cannot practice law from the bench.
The judge meticulously reads count 1, alleged assault against Crystal Nicole Martin on June 8th, 2024. He highlights the maximum penalties, 93 days in jail and a $500 fine, underscoring the gravity of domestic violence. Martin's invocation of corporate entity defenses dissolves under statutory weight. This exchange underscores how actual victim testimony and hard facts eclipse legal posturing. It's a sobering moment where real human impact shatters legal games.
Next court date will be on June 24th. That's 2 weeks out.
So for the record, you have not established status. You have not proven jurisdiction, and you're denying my rights. Is that correct?
I don't know what you think would establish my status, but I do have status to sit in this court.
You are a U.S. citizen. A U.S. citizen cannot sit a bench. You're asking me to sign something that you pleaded for me. Is that correct?
I'm giving you notice of the conditions that I have set, as well as bail.
You said yes, you pleaded for me?
Probable cause. if you are able to post that bail and get out of custody, those are my expectations that you will come back on that court date and that you will abide by the conditions that I have imposed. Those are being ordered today. So that is what's happening today. And we are giving you that notice. You can refuse to sign that notice, and we'll note that you were provided a copy in writing and that you refused to sign.
I do not understand.
Which part of it do you not understand that you have a
I
piece
do
of
not
paper
understand how
with
you can
the
practice
document?
law from the bench.
I'm the judge and I am setting the conditions.
Well, you also entered a plea for me, correct?
What we're doing at arraignment is the plea is being entered. You're not pleading guilty, so on your behalf, I'm entering a not guilty plea.
So, correct, you
cannot-
are pleading for me,
There's
correct?
two pleas.
And if you
Not
plead
guilty
for me,
or
you're
guilty.
practicing law from the bench. You cannot practice law from the bench, so I object.
Right.
That- you're-
I'm going to give you that piece of paper and we're done with your hearing today. We will see you in 2 weeks. Okay? All right.
Jennifer Grant, you will be
Okay.
taken.
In the final stretch, the judge delivers a stern colloquy. He rejects bench law theatrics, confirms Martin's not guilty status, and outlines next steps, pretrial dates, and conditions. Martin's repeated sovereignty claims falter against a firm bench. This closing segment cements that the court's authority endures beyond any fringe legal arguments. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.